Why, hello there. It dawned on me that there are some people that may not want to watch that many videos or really just need a crash course. So I decided to give a crash course of the entire analysis framework and the 3 separate choice of law analysis as well as consideration of judgments. So without further ado, the first step of every analysis, regardless of which one, is step 1. And I actually created a system I call the Eaton Way, E-T-O-N-W-A-Y. Eaton Way, not Eden, because we know what happened to her. So, the first one is E. E stands for the last letter in the word where. So, where are we talking about? So, in the first question, the first thing you ask is, do we have jurisdiction? When you're asking about jurisdiction, you're going to look at 2 types of jurisdiction. And this is based on where the suit was actually filed, okay? So the first thing you're going to ask is there personal jurisdiction? Now, under personal jurisdiction, there's 3 types: in personam, in rem, and quasi in rem. In personam, really all that means is that the court has jurisdiction over that person because they're domiciled there, maybe they have a residence there, a principal place of business is there, they're incorporated in that state, or the injury that occurred happened there because that person happened to be there when they did so, or maybe there's, a service of process happened on that person when they happen to be in that state. So they have jurisdiction over that person. Now, in rem is where the court has jurisdiction over that piece of property because the property is located in that state. Typically, this applies to land, but it could apply to certain types of personal property as well, depending on what it is. So if you have a car, for example, that's in a storage facility in California, and somebody who owns that car lives in Florida and they die, in their will it says that car is going to be given to their son. So that car is in California. Since it's in California, technically speaking, California has in rem jurisdiction over it. And the last one is quasi in rem. Doesn't really come up. It's really only used when somebody is trying to use another person's property to try to get jurisdiction over them for something else. So they typically wouldn't have jurisdiction over this person, but for whatever reason they do now, because they try to tangentially attach their property, and that would require or encourage that person to come to that state to defend their property, and that would allow them to get some other type of jurisdiction over them. Now, if you have a personam jurisdiction, but it's kind of weak, like maybe that person happened to, go to that state once for one business transaction, but like nothing else. So it's not exactly, in personam jurisdiction. So what do you do for certain situations like that? You use what is called the minimum context test established with the international shoe. And that's just going to ask, what contacts you happen to have with this state. Are they strong enough contacts that, this person would expect to be sued in this state if something happened? And if the answer is, yes, we have enough contacts where it's not awful to sue them here, they should have expected this. Even if there is some level of expectation, sometimes the exception under Goodyear can, derail that. And Goodyear is a case that was in France where there was a awful accident on a bus and people were injured. And you have to ask yourself, is it fair or does it violate substantial justice to bring this suit here and to drag this person into court? This is usually known as the acai test, but I use Goodyear because that is a common case in conflicts. And this is really, does this violate the thought process of fair play and substantial justice to drag this person to court in this country, even though they may have minimum contacts? So even if you can satisfy minimum contacts with international shoe, Goodyear can kind of derail that potentially. Now, if you don't have personal jurisdiction, you have to ask, okay, do I have subject matter jurisdiction? Subject matter jurisdiction is going to ask you to look at the basis, typically, of the claim when we're looking at federal question. Now, subject matter jurisdiction can be established with federal question. Federal question is if the basis of the claim contains a federal question about federal law or the Constitution. It has to be like the main thing or one of the main things. It can't just be like a side issue or like a secondary or third issue. It has to be kind of, one of the main meat and potatoes parts of this case. If it is, and it qualifies for subject matter jurisdiction to be brought to a federal court. Now, if it does not qualify for federal question because it's a state law issue, but we are suing in federal court because the people that are in the suit, the plaintiff and the defendant, are from different states. They're domiciled in different states, and the suit involves what is known as a higher amount in controversy above $75,000. That means they have to sue for above $75,000, and they have to be from different states. If you can satisfy that, then you can get into a federal court, even if it is a state law issue. Now, there is an exception. Of course, there always is, and the exception is Erie. If we can show that this person is trying to sue because of a forum shopping issue, they're trying to get into federal court because they think that the law is going to be more beneficial, they're going to get more out of it, and that's why they're suing here, not because of the reason solely based on diversity, then we're not going to allow them to take advantage of the federal law. What we'll probably do instead is we'll let the case continue, but we're going to specifically apply state law. And typically in a lot of cases, they apply state law anyway. If you don't fail Erie, then sometimes they'll apply federal law. It just depends. So that is if you have to see if that claim would hold up. Now, that's the first question, right? Where was it filed? Do we have jurisdiction? Second question is T for what? And that is what happened, right? This is literally helping frame the rest of the entirety of the framework. What happened? What field of law applies? Is it going to be a tort, a contract, a property, a marriage? That's what we really want to know. So what happened here that brought us to court? The third question is who, or O, who? Now, what is this? What do I mean by who? Whose law applies? This is going to look at horizontal inquiry versus vertical inquiry. Now remember, a horizontal inquiry is going to be state law versus state law, where vertical inquiry is going to be state law versus federal law. It's easy to think of horizontal law like this. States typically are side by side because they're horizontal with each other. Federal law is typically going to be vertical because they think that they're above everybody else. Don't know if that was helpful for you, but that's how I remember it. Now, if you don't do this analysis right away, it might be confusing later, so it's important to do it sooner than later. So when you're looking at if you have a horizontal or vertical, first you have to look at, okay, is there any federal court involved? The answer is no, you're probably not doing a vertical analysis. If you have only states involved, then it's automatically probably going to be just a horizontal inquiry. Now, if you do have some states and federal stuff happening, then you probably have to do a vertical or sometimes both. So if you're doing a horizontal inquiry, what you have to look at is what is the substantive law of the states that are fighting right now, right, that disagree. Now, a substantive law is the law that specifically has to do with the legal rights and responsibilities of the individuals of that state. Substantive law is the teeth of the claim, if you will. If you go to court and you sue somebody for hitting your car, the law is, the fact that they didn't follow the traffic rule and they hit your car because it was a red light. Or if you're going to court to probate a will in a state that allows a holographic will, you're suing based on that state law, the fact that they allow a holographic will, the substantive law. What is this suit about? It's about whether or not this will is valid, and according to the state, it is valid. So what's the teeth of the claim? How are we able to argue that we do have a claim here? How are we able to say something has been violated? That is going to be your substantive law. Now, your federal law is going to be something that has to do with a procedure, so the legal proceeding itself, or it has to do with something of the courts. Think of like a court procedure, or maybe a court rule, like the amount of days that is required to respond to a motion, or the statute of limitations. That's considered more procedural, or what evidence can come into court. Think of anything relating to the paperwork that goes into a case, right? And anything that comes into court that you're allowed to show a jury. Anything to do with the court or the session of trial, that's usually procedural. If you have a procedural issue, it's federal. Now, if you have an issue with both types of law, you can apply both. Now, if you have an issue with both types of law, you're typically going to apply the substantive law of the state. And if you have an issue with federal law, you're typically just going to apply the federal procedural law. So federal procedural law gets applied and substantive law gets applied. And typically there's not going to be an issue because the substantive law is about the actual teeth of the claim, whereas the procedural law is like how we conduct ourselves during the trial, how we conduct ourselves during the legal proceeding. So there can be further confusion, but that doesn't get until later on in the analysis. So for the gist of this is, you just gotta figure this out. It's not too complicated, don't overcomplicate it. Now the next question to ask, I ask this one always, you can omit it if you want to, but the one I always ask is step 4, or N, which stands for when, which is the last letter in when. And this one is going to discuss renvoi. So renvoi is a legal concept that is applied when we're using whole law. Now, there's a difference between internal law and whole law. Internal law is the law of the state, the substantive law of the state. Just learn what substantive law is. So internal law is a substantive law. Now, whole law is the state's substantive law plus their choice of law. Now, a choice of law is going to be first restatement, second restatement, or governmental interest test, okay? Now, when you're looking at when you apply renvoi, it's typically going to usually be for property, marriage, or divorce issues. You can apply renvoi in other situations, but typically you do not want to because it creates a lot of issues. So if you do have an analysis where you say, you know, this has to do with divorce, we're going to apply whole law because it has to do with divorce and it makes more sense to do so, then you can get out of applying renvoi and all the complex analysis because it just goes in circles by saying, although we would typically apply renvoi in this situation, we're not going to because of these reasons. It creates a circular reasoning. There's no real efficiency with the courts. It affects judicial administration. And it does not allow for any finality or efficiency because it goes back and forth between each state's law and there is no conclusion. Because of these reasons, we're not going to apply renvoi. We're going to continue with this type of law instead. So renvoi is applied if there are certain exceptions. And the problem is when renvoi is applied, we're applying the whole law, and the whole law is very circular because sometimes when you do a choice of law clause, it'll have you land back at the opposite state as opposed to your own, and that's why it gets complicated. Not always, but a lot of times it does. So let's just say that you find renvoi applies. I'd probably pause here and benchmark it and continue your analysis and see what the answer is. If the answer is going to become circular, then you, in your answer, go back and say, although we would have applied renvoi, as you can see, the answer would have been X, and because it would have been X, it would have required us to go back to this other state and start all over again, which would have caused a circular reasoning, a circular pattern. It would have not led to any type of justice or finality, therefore we're not going to apply renvoi, and that's it, right? So that's what renvoi is, that's how that works. Now, step 5 is W. W stands for how, and this is how are we going to resolve this source of law issue, and that's going to be based on if you have a first restatement, second restatement, or governmental interest inquiry. Let's say that we have a first restatement inquiry. So step 6 is going to be first restatement. Now what you do for step 6 is there's actually really only 2 steps in step 6 that I created that I think make the most sense. And that's going to be lex loci. Lex loci applies to the actual potential field of law, okay? So we have lex loci delicti, which is for tort, which says that we, under the first restatement, say where the tort happened is the law that's going to govern. So if the tort happened in California, the law will govern in California. It's very simple. It's very easy. It's not as easy anymore once you get past the restatement, the first one, but we'll continue for now. And so where it happened, that's how it works for tort. Now, lex loci contractus has to do with contracts. So that discusses one of 2 things, either the formation or performance. If the contract was formed in California and the lawsuit has to do with the issues of the formation of the contract, we're going to look at where the contract was formed. If we have issues with the performance of the contract, we're going to look at where the contract was supposed to be performed or where it was performed. That state is going to be the law that governs. Now, you also have the field of law property. The situs rule governs here. Situs rule says where the property is physically located, the state that it resides in, that law will always apply. Then you have marriage. This is the one that's a little complicated. This one depends. So you have 2 major rules in marriage. You have the celebration rule and the domicile rule. The celebration rule states that if you get married in a state and you follow all of the procedures and regulations that they have for marriage and for a valid marriage ceremony, if it is valid in that state, then it will be valid everywhere. The domicile rule says if you have two people that are domiciled in a state and they get married in that state and they follow the rules of that state for the ceremony, then their marriage is valid. Now, there is an exception under Section 132, okay? Section 132 says if the marriage violates a positive law or violates a written law that we have, we will not honor a marriage that was done outside of our state. So obviously, if it is a marriage that there's a rule against it on their written books, it would have not happened, so domicile rule doesn't apply to that. So this is an exception specifically for celebration. So if, for whatever reason, you get married in Utah and you move to California and something about your marriage is against our state law or our state policy, we do not have to and will not actually acknowledge your marriage as valid at all. So that's what Section 132 says. But remember, it has to be written in the law. If it's not written in the law, they don't have to actually enforce or find that the marriage is valid if they can prove Section 134 applies. Section 134 says that if this marriage is so fundamentally against our state public policy, our state belief, against justice and good morals, we find it so egregious, we do not have to find your marriage to be valid. We do not have to acknowledge it, and we won't. So you can get away from the celebration rule if you can show Section 132 applies for written law or Section 134 applies because it's so egregious to your state public policy. Now, there's an exception to both of those, and that's under natural law. So there's positive law and natural law. Positive law is the rules and regulations governing the marriage and everything about how you get married, right? That whole process. That's what positive law is in a state. Natural law is the underlying meaning and inspiration of the marriage. And I'm sure you're aware that every state has a different definition of that. So some states have a definition that marriage was created between one man and one woman. It was a creation of God. And it has to follow those principles. And if it doesn't follow those principles, they're not going to acknowledge the marriage. For example, you have a lot of current social issues about same-sex marriage or partnerships. In California, same-sex marriage is considered a valid marriage. I don't know what state doesn't allow it. Let's say Texas doesn't allow same-sex marriage. I could be wrong, I don't know. But if Texas doesn't allow same-sex marriage because they believe that marriage is between a man and a wife, and it was created by God, and therefore there are certain rules and regulations, and the meaning and the principles that surround marriage just don't support a same-sex marriage, and therefore the underlying reasons that we believe marriage exists, this natural law that we hold so close to us as Texans, because of that, we're not going to acknowledge your marriage in California, even if you did it legally in California, because it violates how we interpret natural law. I think that's the key, is the exception to the exception is, even though there's two exceptions, you can overcome both of them or either of them if you can show and prove that your interpretation of natural law says X. Now remember, natural law is the underlying meaning and purpose of marriage, not how we govern how to get married or the marriage itself. And the second thing that you ask in the first restatement, once you've done all of this, depending on what your field of law is, the second thing that you ask is, was the right vested here? Because remember, the first restatement was also known as the traditional test, which was also known as the vested rights approach, which asks whether or not your right was vested in the state in which you brought the suit. Now, what does that mean? If you are injured in Texas, that means that your right vested in Texas. If you got married in Texas, your right vested in Texas. It's typically associated with the place itself, and when that thing happened, look down, where are your feet standing? That is the location of the vested right. So that is the first one. Now let's say step 6 is going to take you to second restatement instead, because that is the choice of law that you're in. Second restatement has a little bit more nuance to it. So the first thing you're going to ask in the second restatement is, what are the interests of either state? So if we have state California and state Utah, what is California's interest in this matter and what is Utah's interest in this matter. You're going to ask the law that they both have regarding this problem, and then you're going to ask the general purpose of the law for this problem. Now, the second thing you're going to do depends on what field of law. So typically this is going to be usually used for torts or contracts because second restatement was created because they didn't think there was enough fair results. So let's just say you're in tort law. So the first thing you're going to do if you're in tort law depends. You have to ask, is this a personal injury tort or not? If it's not a personal injury tort, you're going to continue with 188 subsection 3. If it is a personal injury, you're going to have to ask 3 questions, okay? The first question is, what is the underlying policy principle for the law at question here? So that's asking you, what's the policy of the law? And what is the underlying principle of the law? And you're like, that sounds very similar. So usually what I call it POP because it's easy to remember that way. It's policy overarching principle. So when you're looking at the laws that is in question regarding the tort, the personal injuries, you have to ask yourself, what law was broken? Why was that law made? What was the reason they created this law? If we don't follow this law, was the entire reason the law was created completely useless then? If we say we're not going to follow this law, is there any reason that we have this law in the first place? That's called impeding the law. So if you have a law, and the underlying principle of the law is to prevent people from speeding, and the reason we created that policy reason was to protect our citizens. So if we do not follow this law, we're not really able to protect our citizens, then you're impeding that law. Now, if you are allowed to use this law and enforce this law, it's furthering your purpose, which is to protect your people of your state. So you look at the law, the principles it's attached to, then you look at the reason that they made this law and the actual policy behind the law. Once you look at whether applying the law or not applying the law furthers the purpose of the law or impedes the purpose of the law, then you have to ask, if we apply this law, is it going to be difficult for another court to apply a different law state? Or if we don't apply this law, is it because it's going to be more efficient for us as a court to apply our law? Typically with tort claims, there's really not going to be a lot of issues regarding judicial administration of another state's laws because most tort laws are pretty similar across the board. And every state has a tort law. It's not like you're going to a state that doesn't have a tort law of any kind. If you do, then I would say, okay, it's probably very difficult for them to apply that law because they've never done it before. But if everyone has tort law, it's not going to be that difficult. Once you ask those 3 header questions, then you continue into section 188 subsection 3. So the only difference if you have personal injuries, you ask those 3 questions, then you continue to the presumption. So section 188 subsection 3 is a presumption under torts that states if the tort occurred in this state, we presume that the law of that state will govern. Now, you don't stop there. You should then continue to do an analysis under section 188 subsection 2. 188 subsection 2 is what the majority of this second restatement is about. Second restatement is about counting contacts, or otherwise known as most significant relationship tests. Section 188 subsection 2 for torts asks you 4 major questions to determine how many contacts go in favor of you versus another. Now the 4 questions you're going to ask under 188 subsection 2 is, where did the actual tort occur? Where did the conduct that caused the tort occur? Who was involved and what was the nature and center of their relationship? And where are those people domiciled? Now, let's say I am driving in Maryland and I decide to drive into Virginia and cross this large bridge that connects Maryland to Virginia. And as I'm driving, I start to speed. A cop starts to chase me. I don't slow down. A huge pursuit starts. And for whatever reason, there's a bicyclist on this bridge. Let's say, as I'm driving in Maryland, on this bridge. I'm still in the state of Maryland. I hit the bicyclist in Maryland, and the bicyclist flew over the state line into Virginia. And when they flew over the state line, there happened to be a butcher knife on the ground in Virginia, on the road in Virginia. And he fell on that, stabbed his heart, and bled out instantly. Okay, graphic, sorry. So, first question, where did the tort occur? The tort occurred in Virginia because that is where that person died. What's the tort? Murder. Where did the conduct that caused that tort occur? Maryland, because the person was speeding in Maryland. He hit that bicyclist in Maryland, so the conduct that gave rise to this tort happened in Maryland. Now, who were the parties? Well, let's say that the crazy driver, was from Maryland, and the bicyclist was also from Maryland. So that would mean that the driver and the bicyclist relationship centered around Maryland because all the contact happened in Maryland. The relationship began in Maryland. They only know each other because of the accident that occurred in Maryland. Therefore, you would argue that because these people's relationship is centered around Maryland, it's in Maryland. Then take it a step further, both parties are domiciled in Maryland. So when you're looking at that, you're going to say, okay, we see that this person died in Virginia. So we put, if we're counting context, Virginia, 1. Okay, Massachusetts, we see that the conduct of giving rise to this tort happened in Massachusetts, 1. People's relationship is centered around Maryland because that's where the contact happened. That's where the conduct occurred. That's where the speed started. That's where the person was bicycling. That's where the person was driving. Everything about their relationship was centered, for the most part, around Maryland. So Maryland, another contact for you. Lastly, they're both domiciled in Maryland. So boom, another contact for that. That means the presumption is it's where the tort occurred. In this instance, the tort occurred technically in Virginia. But according to 188, subsection 2, it looks like we should technically apply Maryland law. Now, you can't stop there. You're not really sure now. Even though the presumption seems to be destroyed, you have to double check. And how do you double check? With subsection 6. Subsection 6 is based on 5 principles. There's actually more, but we boiled down to 5 principles from the JC case, okay? The 5 principles that help you further flush this out start with number 1, comedy. Not comedy like, I'm hilarious, which I know I am, so thank you. It's comedy with a T. We look at interstate comedy. Now, there's 2 tests that you have to actually apply. The first one is the harmonious test. The second one is commercial intercourse. Now, when you're looking at the harmony test, what this means, and it's either regarding a foreign law, which can be a different state's law or a different country's law. When you're looking at that law and whether you apply that law or your own, you have to ask yourself, if I don't apply their law, could it harm the harmonious relationship that I have with that state or country? Or would it not affect it? If it could affect the harmonious relationship of the states or that state and that country, then you might not want to apply that law. You might want to apply the other law instead. Now, the second test is going to be commercial intercourse, which has to do with the economy, has to do with interstate commercial transactions. So if you have 2 states right next to each other, say I don't know what's next to, I'm sorry, I'm bad at geography, California and Arizona. If you have 2 states right next to each other, and if we apply California's law, Arizona's going to be so mad it's not going to sell any more salsa to California. That would show and indicate that that's going to affect the intercourse between commercial transactions because obviously the states don't want to do business with each other anymore. More broadly, you can look at, would this affect the economy in any way? If it affects the relationship so much it addresses and changes the actual current transactions, it may change the flow of commerce, it may change the economy in some sort of way, then it would negatively impact that test, the commercial intercourse test. This also obviously applies to states that aren't right next to each other or other countries. If, people do business with all kinds of people all the time because of globalization. So if applying one law versus another will detrimentally impact their ability to work with you because they just don't want to anymore, or they find it very unfair, or that really makes them worried about doing business with you, or for whatever reason, that could cut against it. Now, the second factor under the JC test is going to be whether there are expectations of the parties that go in favor of applying this law. So expectations of the parties is pretty simple. What these people have assumed to have been hauled into court here kind of goes back to the basic question of international shoe. And you could use international shoe here to really figure out, what would the parties have expected? Would they have thought to have been brought into court here? Would they have thought that this would have happened? Were they associated with this state enough where it's not that much of a remote possibility? That's really what they're looking for there. Now, the third one is actually one of the most important when you're looking at the JC test, and that is the interest of either state given the underlying law. So when you're looking at the state that is wanting to have their law applied, what's best is to look at this law for, say, the location that the suit was filed in. So if the suit was filed in Virginia, we're going to look at Virginia. We're going to say, okay, what's the interest that Virginia has in this suit giving the underlying law? Okay, the underlying law of Virginia says that murder is a felony, that they do not tolerate murder of their citizens, that they do not want people to be killed on their grounds, that they are totally against it, and they want to encourage tourism, and it really harms them when people are murdered there, right? Seems like they have a pretty strong interest in preventing murder, but they don't really talk about murder of another person that's not a resident. They talk about tourism. But was this person touring Virginia or just biking because they were trying to get a good workout? So does this weigh in favor of Virginia or Maryland? Well, because it's a state that has a lot of tourism, I would argue that it probably weighs in favor of Virginia because they do want to reduce any bad acts that happen in their state, even if it's not a resident, even if it's not a tourist, because they just don't want to ruin tourism because they make a lot of money from tourism and they need that income. So if we're going to look at it from that perspective economically, which is always a very influential factor, then I would say that, yeah, we're not going to apply Maryland law, we're going to apply Virginia, and that would weigh heavily in favor of Virginia. Now, the fourth factor is judicial administration. And this goes to whether it is difficult for a state and the court in that state to apply a law that's different than theirs, to apply somebody else's law. Sounds familiar, doesn't it? So if it would be very difficult to apply this law, or by having the litigation happen here, it would be very inefficient, very ineffective, very difficult, very challenging. It would make it more expensive on everybody. It would be detrimental for the resources of one state, or it'd be detrimental to apply this law because it really heavily affects the justice. How does it affect the administration of the actual case, of the trial if there is one, any of the motions, any of the follow-ups, and the punishment? How is that all affected? The last question is the other very important one, and there's only two very important ones in JC. It's the third one and the last one. And the last one is the competing state interests. So we broke down in depth what Virginia's interest is. So for step 5, let's break down in depth Maryland's interest, and then we'll compare the two. Maryland has an interest in people not committing murder. Maryland has an interest in people not committing murder in their state, let alone any others, but specifically their state because they want to protect their citizens. They find murder to be a felony as well, hold people liable for murder, even if it results from an act that was not, intentional. For example, driving and running away from the police, that they may have not intentionally have murdered somebody, but you could argue that by doing so would have led to murder potentially, therefore they're going to charge them with felony murder. Now, they have an interest in their residents being protected. Were their residents harmed here? Yes. Were their residents harmed in their state? No. But the conduct happened in their state that led to this. It was their residents that created this problem, their residents that, ended up being implicated in this. So I think this could potentially go either way, because although the person did not die in their state and they want to protect people that die in their state, it did involve both of their residents. Because it involved both the residents, I would argue that only just slightly Maryland has a slightly bigger interest here, but not as much. And the reason why is because that person wasn't killed in Maryland. If they had died in Maryland, then I would say 100% Maryland has a stronger interest here, but it's only just slightly a little bit more. So I would say just slightly the last one is probably Maryland. But for the last one, if you are on the edge, excuse me, for the last one, if you're on the edge, you can always just put it as a drop. You don't have to necessarily choose if you can. Now, with that said, let's count the contacts for section 6. So if you remember, presumption was in favor of Virginia. 188 section 2 said it's going to be Maryland. Now let's look at section 6. Section 6, first one, comedy. Does it really affect anything depending on whose law it applies? No, not really. They both do work. They both obviously work a lot with each other. They both obviously have a lot of business with each other because they're neighboring states. Applying one law versus the other really doesn't make a huge difference. Now the second one has to do with expectations. They probably would assume they would be sued in Maryland, but if one person's, biking into Virginia and the other person's driving into Virginia, it probably isn't that crazy to think that they could be sued there, so that's also a wash. Now, third one, who has the greater interest? According to the state interest underlying issue, I would argue Virginia for that one, so Virginia has 1 point. Now, for judicial administration, it's a wash, not really a huge deal. Now, the next one, I would say it's Maryland, but let's just say we put it at a wash. That would mean that we only have one contact that adds to this at all because everything else was a wash, and that would be Virginia. So presumption Virginia, 188 to Maryland, section 6, Virginia. Based on that, technically Virginia would win. However, if we didn't make the last one a wash, Maryland would win because it would be an additional contact. But even if you have something that says like, well, we have 1 point for Virginia, 3 points for Maryland, plus a presumption, you can overcome a presumption with points. So in this situation, I think regardless, Maryland would win because technically you can use 188 and section 6 to overcome. And in this presumption, even though it was for Virginia, when you count contacts, Maryland clearly has more contacts, even though it's only a few more. Now, if you're not as conservative as I was, you're a little bit more liberal with your points, you would see that clearly Maryland would have won regardless. Therefore, you would apply Maryland law. Did I say Virginia? No, Maryland would have won regardless. Therefore, you're going to apply Maryland law. It's very easy, especially because both parties are from Maryland. You might have had a different answer if not both parties were from the same state. Now, that is how it works with counting contacts with torts. Contracts are a little bit more complicated, so I apologize. There is a presumption with contracts, and that presumption is under 188 subsection 3, if the negotiation and the performance were done in the same state, the presumption is that that state's law is going to apply. Now, if there is a presumption, don't stop there. Just in case, I didn't hear you, you're not loud enough. You're going to do section 6, just in case, to help you count those contacts, because after all, it is the second restatement. You're like, why don't I do 188 subsection 2? Well, you kind of halfway did it when you tried to figure out the presumption. You don't have to do it. You really just have to follow up with subsection 6 just to make sure. Let's just say there is no presumption or there is no choice of law clause. In that case, you're going to do 188 subsection 2 analysis, just like you did for torts, but for contracts, a little different. It's actually 5 factors. First factor is, where was the actual contract negotiated? That's where you talk about it, you discuss the terms, all those things. Where was it contracted? That's where you finally said, let's do it. You signed or you shook hands or whatever. Then the next one is performance. Where was the contract performed or supposed to be performed? This one can get tricky. If you're supposed to provide something and say a car in lieu of money, look and follow the money because sometimes that can get confusing. So if the money exchanged hands in Utah and you picked it up in California, technically the money exchanged hands in Utah, so that's when the contract was fully performed because the consideration was fully satisfied. Now, when you're looking at performance, you have to also look at if it was a product in lieu of a service or if it was just a service. So where was the service supposed to be conducted or what was it for? That might give you an idea for performance. Now, if you have performance in 2 different states, that might be a wash, okay? Now, the next question you're going to ask is who are the parties and the center of their relationship? Why do they know each other? How do they know each other? Where do they typically talk? How do they talk? Is it typically over email from different states? It'd be a wash in that case. Do they fly into Texas once a month to discuss business? If so, then the center of their relationship is probably Texas. Then obviously, lastly, you're going to look at the location of these parties. What is their domicile? If the one person lives in California, the other lives in Utah, and they're domiciled there, boom. Domicile member can be principal place of business, place of incorporation, wherever their main hub is. So those are the 5 for contracting. Now, once you do 188 subsection 2, regardless of how the context turns out, if there's no presumption and no choice of law, you have to continue to subsection 6. Subsection 6 is applied the exact same as it is in torts. The only difference is the context, and it's about the contract itself. When it comes to contracts, the where is very important, and the economic principles that surround the contract are more important. So pay really close attention to where everything is happening and who benefits the most from this contract, and who would really be hurt the most if something bad happened to this contract on a state level. Okay. Now, you're probably wondering, what if there's a choice of law clause? Well, if there's a choice of law clause, we're going to assume that it's enforceable and applies. But you don't just automatically just say, oh, choice of law, I'm done. You actually have to go to 187 subsection 1. 187 subsection 1 looks at the problem of the litigation, the reason they filed the suit, and then they're going to ask, okay, in this lawsuit, we're upset about something very trivial, like the font on the contract, or the what a word means for interpretation of a contract. Say they're ordering pink fuzzies and they're angry about what the word fuzzy might mean. Can we use UCC gap filler? Can we use a gap filler based on the parties' trilogy, meaning their previous negotiations, their previous course of dealings? Can we use anything from the industry standards to kind of imply what we mean? If the answer is yes, because we could have contracted out of this problem, meaning that we could have created another term to make this easy. We could have created another term to make it so that this problem did not exist, because this problem is not really material to the deal itself. Then it's probably what is called a default issue. If it's a default issue under 187 subsection 1 and there's a choice of law clause, you keep the choice of law clause and enforce it. Now, what if it wasn't a default issue? What if, although it is a choice of law clause, but the problem that we're suing against and for is not something that is super easy to fix. It's not something that we can just interpret. It's not something that we could have contracted out of. It's something bigger than that. It's material. So if something is material and we can't contract out of it, and it's something that we should have really specified because there's no gap filler to use here, then it's known as a mandatory issue. When you have a mandatory issue under subsection 187(2), there's two questions to ask. The first one is going to be the choice of law that was determined in the clause, okay? That law that they said, we want this to apply. You have to ask, does the state that you listed in that contract, do they have substantial relationship with the transaction that's in the contract, that's the heart of the deal? Or does that state have a substantial relationship to the parties of the contract? If the answer is yes, then you can apply the choice of law clause and enforce it. If the answer is no, you have to go to the second question. The second question asks, is there a reasonable basis for the law that you chose in your choice of law clause? If the answer is no, you have to continue to subsection 6. If the answer is yes, then you can apply the choice of law clause, but there may be an exception known as the material interest exception, which states if one state has a material interest that is far greater than the other state, that in fairness ought to be enforced, then it blows the whole choice of law clause out of the water. Now, when it comes to the choice of law clause, the biggest thing is, especially the second part of 187, section 2, is reasonable basis just has to be if it's reasonable to the parties. Like if they had a good reason for doing it, like in 1-800-JUMP case, they chose Washington as their choice of law clause because what happened was, as one person in the contract was way over here in this state and one person in the contract was way over here in this state, and they said, well, we chose Washington because, you know, it's in the middle. I guess that's reasonable, right? That makes sense. You know, less traveling for both. Everybody has to travel, but let's make it fair. As long as you have something reasonable that's objectively reasonable, it's fine. But it has to be objectively reasonable. So that's how that works with choice of law. Typically with choice of law, you wouldn't do 188 subsection 2 because you don't need to do 188 subsection 2 if you have a choice of law clause, but then you have to do 187 instead, and you still have to usually follow up with section 6. So that's the second restatement. I know, so fun. Now the next one is the governmental interest test, and the first question is the same. What is the interest of the state, right? What is the interest of either state? When you're looking at either state's interest, you have to ask, what's the law that we're arguing about? Once you ask what the law you're arguing about is, that's where this gets a little tricky. Then you have to ask, okay, is the law a loss-shifting law, or is the law a conduct regulating law? A loss-shifting law is specifically going to be about protection. If the law itself is somehow about protecting somebody from something, then it's loss-shifting. If the law is about regulating the conduct that people have, the behavior that they exude in a specific state, it's conduct regulating. Conduct regulation laws are usually going to be very, very specific about the where. Law-shifting laws are usually more specific about the who. Now, you have to remember when you're looking at law-shifting versus conduct regulation, domicile is very, very important. If we're trying to shift laws to protect a citizen of our state, great. If somebody is trying to sue in our state, sue somebody else to get advantage of our law, no, that's not how it works. Our law is meant to protect our people, not you. It's the same thing with conduct regulation. You can't just sue where you want. So the point of this is really check to see what type of foreign shopping they're trying to do. The people that can take advantage of the law is the person that's domiciled in that state, depending on the circumstances. Not always, but for the most part. So let's just say you've decided that it appears to be a law-shifting statute, and it appears to be in favor of the plaintiff, and it's in favor that you apply the state that the plaintiff is domiciled in. Okay, double check yourself. Go to section 2, or step 2, which asked you, based on what came out of the interest of the states, is there a conflict of law regarding the interest? This means, is there a true conflict, a false conflict, or an undisclosed conflict? If it's clear that the law shifting of state A would apply because the point is to protect somebody and somebody got hurt there, you have to ask, okay, does the other state have an interest even if their law doesn't apply? Do they have an interest in this litigation? If they do have an interest in this litigation, it's significant. Both people have a significant interest in this law and what happens. That's called a true conflict. If you have two states going like this and you can't figure out who to apply, then you apply the law of the state where the court sits, where the suit was filed. So if I file a lawsuit in Virginia Beach, Virginia, and Virginia's law applies and so does Maryland's, and both are going like this and we can't figure it out because it is a true conflict, we're going to apply the law of Virginia Beach, Virginia, because that is where the court sits, because that is where I filed, and that is the forum law. Forum law is the jurisdiction that has your case because you originally filed there. That doesn't mean they actually have true jurisdiction, they just currently have that case. Now, what if it's a false conflict? That's where you look at two states, and you're like, do they really have a conflict here or no? If they do really have a conflict, then you're back to true conflict. But if you really look at it, does this person really have a skin in the game? Do they really care what happens? Good way to check about this is to take a step back and say, if we don't apply this person's law, how is this state harmed? How are they benefited? If they're benefited but not harmed, they probably don't have a huge interest. If another state is benefited and harmed, they're the ones that probably have the interest. So it might look on its face that they both have an interest, but really only one does. In that case, you're going to apply the law that has the state law that has the greater interest in the case itself. Now, the last one is undisclosed. That is, no state really could give a hoot what happens. No one has a strong interest. Nobody really cares. There's no law shifting that applies. There's no conduct regulating that applies. There's really no interest other than the fact that they're domiciled in one state or another. Well, if it seems heads or tails who we apply, then we're going to apply default to forum law. So we're going to apply the law of the state where the suit was brought. And at the very least, it was brought there. So they have some level of jurisdiction there, some interest because they have the case. Now, There's one more question to ask, and because the government interest test is a balancing test. Once you figure out the first two, then you have to look at, okay, let's balance the interest here. You're going to do 188 subsection 2 regarding domicile and contacts, as we're counting contacts technically. So we're really just going to ask, where did the injury occur or what happened? Where's the conduct of the thing that happened? Who was involved, the center of their relationship, and where they're domiciled. That's really all you're doing. You're asking the same 188 subsection 2 questions you would typically ask for a tort. I guess if you have a contract, you could do the contract, you could apply the contract version, but that's all you're doing. Once you apply that, then you balance the interest that you already knew about, and you're like, well, this and this. So say that based on the true conflict, you apply forum law, but based on the contacts, it makes more sense to apply the other law, then you would switch over and apply the other law. But if after counting contacts it seems pretty even, then you just default to the forum law. Now, that's if you have the governmental interest. Now, whether you have first, second restatement, or the governmental interest, you always proceed to step 7, which stands for why, and Eaton way, which stands for why do we have any limitations on our answer? So, in the last step, you ask constitutional limitations or public policy limitations. Constitutionally speaking, when you're looking at the why, you want to know if the due process or full faith and credit clause are implicated at all. If you want to know if the due process clause is implicated, you have to ask, did both parties have a chance to fully and fairly litigate their case? If the answer is yes, then you probably don't have a due process issue. Remember the Durkee case where one person filed suit over a property issue? They participated in the litigation, they lost, they tried to sue in a different state. No, you had a chance to litigate, we didn't violate your due process. Now, another thing that you get to ask when you're looking at due process is whether, if we as a state have substantial contacts or aggregate contacts or significant interest in applying our law that is not arbitrary or unfair. All this is saying is, are we applying our law because we're biased and we think that we're better? Or do we have a reason, a substantial reason, because we have substantial contacts, or we can add up all of the reasons why to substantiate us using our law? Now, if you're able to say that and you can prove that it wasn't arbitrary or fundamentally unfair, then you haven't violated due process. Now, the next question that you have to ask is whether there's an issue with full faith and credit clause. The full faith and credit clause is only asking whether you have an obligation to apply another law, and if you cooperated with the other law or the other country or other state and you respected their other law or their state. You are not obligated to apply another law, but if you're purposely not applying it because of some violation of the full faith and credit clause because you do not honor their rule as much as your own, then you violate a full faith and credit clause. Full faith and credit clause is really not too challenging, but when you look at the constitutional analysis or both constitutional, the due process of full faith and credit clause, look towards the Phillips case or the Allstate case to try to beef up any type of suggestions or comments if you have extra time, because that's really where you're grappling and you get a lot more of your rules and you get to determine whether or not you apply something based on that. Now, another thing you ask in step 7 is the public policy. Now, when you're looking at public policy, it kind of bleeds off of the federal constitutional inquiries, and the reason why is because as a state, you're not obligated to enforce or apply another state's law, and that's not a violation of the full faith and credit clause if you as a state have a fundamental public policy reason to deny applying a foreign law. Now, foreign law can be a different state's law or an actual other country. Now, what do I mean by strong public policy? It has to violate a public policy that is something so pivotal to that state that if they applied it, it would completely jeopardize justice, or it completely jeopardizes their perception of good morals. And the policy that they have encourages to punish the behavior that you're asking us to consider, that you're asking us to apply. What do I mean by that? Child labor is a great example. If we as a state deem child labor illegal, and that's against our public policy, and you want us to enforce a law from another country regarding a contract issue, we can say, although you have more contacts, although based on full faith and credit, we should really consider and apply your law, we're not going to, because it violates a strong public policy of our state. It totally jeopardizes what we believe is just, what we believe is a good moral thing, and we're not going to ruin or impact our country or our state just to take your law and apply it, even if it would be the right thing to do based on any of our choice of law analysis. That's public policy. Now, step 8 is only if you have to do it, but technically it's not step 8, it's just an additional consideration. If you have a judgment, you have to ask yourself a few questions. Okay, there's like 6 questions. First thing on our judgment you have to ask yourself is the judgment valid? It's valid if the court that gave the judgment had jurisdiction over the parties or the actual case. They had the proper procedures followed throughout the case. It was fair procedures that were followed. And then they ask whether the actual judgment is final and complete and conclusive. Then they're going to ask, was it also a reasonable judgment? Was it fair? Again. Then we're going to ask, is there a public policy exception that would cut against us actually accepting this judgment? For example, child labor or selling, like slavery is another example. Then you look at the full faith and credit clause. If there's no public policy issue and the judgment was fair, final, reasonable, can we or should we enforce it? Are we required to based on the full faith and credit clause? Then you're going to ask, okay, well, is it a procedural issue or a substantive issue? Because remember, substantive is the teeth of the claim itself, the law itself that we're talking about, that we're questioning. Procedural has to do with the procedure of the court. If it's a judgment and we have a procedural issue with our court, we're typically going to use our court's procedure, just because using another court's procedure just wouldn't make sense, because that's with the court proceedings and how we operate as a court, so we're not going to apply that. But if it's substantive law, typically going to enforce it fully. Now, the last question you're going to ask for the judgment, it has to do with preclusion. And preclusion is going to be whether there is an issue or claim that's been precluded. With that, all you're asking is, have they already sued based on this claim or based on this issue? If they have, has all of the process been complete? There's no more appeals, nothing to be done. If the answer is yes, it's complete, then you're going to ask, in the judgment itself, does it state that there will be no more litigating of this issue or no more litigating of this actual claim? If that's the answer is yes, then the issue has been precluded or the claim has been precluded. That's important, because when you're looking at whether to enforce a judgment, you're looking in the sense of when somebody sues and there's a response saying, well, no, you can't sue me because of this judgment, or somebody brings a judgment and says, I want this enforced. They're going to think about it like this. They're going to look at it. Can we enforce this? Should we enforce it? Is there any issues why we shouldn't? A great example or exception, I should say, is the Washington Light case. It discusses a workers' compensation claim. It's a supplemental claim to another claim. So one person sued, or the person sued in one state got a workers' compensation benefit, and then they sued a few years later in a different state. And they said that even though this claim has already been litigated and resolved and there's already a judgment on it, we're not going to preclude you from getting additional benefits on that claim, because a supplemental benefit is not precluded and it's not the same thing, because technically in workers' compensation, it's an administrative procedure. It's all separate. The board members are all separate. It's not like they share information as they would across the state lines. So if there is a preclusion issue, sometimes that can help you kick a case out or help you reduce the issues that is being discussed, or potentially help further solidify which issues are going to be handled. So that's about it. There is sometimes something that comes up about class actions. And that one's very, very specific about general jurisdiction and specific jurisdiction. Doesn't come up too much, but if it were to come up, there was a case that had stated that it would be more fair to break it apart in the states based on the location of the individuals. But I don't have an analysis prepared for you for that. I apologize. But other than that, these are the steps. I hope they were helpful. Always remember, you go through step 1, 2, 3, 4, 5, And then step 6 changes depending on the fact pattern. Always go to step 7, always step 8, maybe if you have a judgment. Good luck.